Hello, I'm Trevor. I'm one of the magistrates here at Lucas County Probate Court. I work for Judge Puffenberger, and welcome. We're going to talk about wills today, last will and testament, not living wills. And so we're going to go through some of the basics. This will make it easy for a lot of people come in and they have questions about last will and testaments, and they'll also pull out a power of attorney. They'll put out a living will, and they'll say, I've got my mother or father's last will here, I've got my sister's last will here, and it's not a will at all in the sense that we understand. And that it's a very easy thing to misunderstand because it says will, it says living, it's signed, it's witnessed, but yet it's not a last will. And so that's what we're going to unpack a little bit in our little time together. A living will is made while you're still alive. A living will is carried out while you are still alive. It's a collection of end-of-life decisions that you've made ahead of time and said, if something happens to me, if I become unconscious, if I'm unresponsive, if I'm in the hospital, here are things I do and do not want done to me. I may want to be fed artificially. I may want hydration, which is giving me water. I may want none of those things. That's what a living will tell you. If I go into cardiac arrest, I may want to be restarted or just be no code. Let me just pass away peacefully. I don't want to live any longer. Those are parts of a living will, and you commemorate them in writing, and they are witnessed with your signature and the signatures of other witnesses who are called attesting witnesses, because they're attesting that they saw you do this and that you were in the right frame of mind when you did it. And so a living will deals with end-of-life issues. It deals with what I'm going to do, how I'm going to die, and those are respected by the state of Ohio, and those are to be honored. That is not a last will and testament. A last will and testament is similar in the sense it's something I want done and I make it while I'm alive, but it's all about here's what I want you to do with my stuff when I'm dead. Because when a last will becomes operative is when you are dead. And that sounds sobering to us, but it's not. It says I want, it can be general, it can be specific. It says I want my 4-carat diamond ring to go to my niece, Sally. Or it can say, I want to leave everything to my spouse. And if he or she is not alive, then everything to my children equally. And that's usually the way we see wills. People leave things to their spouses, and then if not, they leave them to their children or their friends or family. You can even disinherit somebody by saying, I specifically don't want anything to go to Bobby because he wasn't around to help me, and you put that in writing, and that will be honored also. So a last will and testament deals with your property, your personal property and your bank accounts, as well as all of your personal belongings and any real estate that you own, and that also, by the way, includes any cars that you may own. Because no one can say otherwise that you didn't want something to be done. And now that sounds a little awkward, but what it means is I know what Mom wanted. Mom wanted Great Aunt Dorothy's bone china that came from Germany to go to our family equally. And she would talk about this all the time. When you make a last will, you can ensure that your wishes are carried out so that you know that people fight over property. Unfortunately, when somebody passes away, over 20 some years of working here, I've seen a lot of greedy people. They fight over things. And unfortunately, probate court becomes divorce court for siblings. All of the angst that they kept in check while parents were alive comes out, and it gets very ugly quickly. But if mom or dad or a spouse or your brother or sister leave a last will and testament, we know what she or he would want, and we know how they want to distribute it. You can even give things to charity, to environmental causes. You can give things to for a trust for your pets, so that anyone inherits your dog or cat or other exotic animal. You leave money so that those pet children of yours are taken care of in the event of your demise. Really doesn't. That a will, as I said before, is only operative when you're dead. There's a finality to it. And even then, someone will come in, usually without a lawyer, and that's not their fault. They're asking questions, legitimate questions. But what he or she asks is, well, I'm Peter. I was named in my mother's will, and she just passed away. So I'm the executor, right? And I know that's a foreign word to a lot of people. An executor or administrator are old Latin words that mean the personal representative of the estate. So when somebody passes away, somebody has to be appointed, and that's the key. Just holding up the last will does not make you the executor, even though it says my executor is Peter or Susie or whoever you want. Rather, it has to actually be filed with the probate court, and you need letters of authority from this court to be able to act as that person's legal representative. So for example, if I'm alive, Peter can't get into my bank accounts unless he's signing on them. Peter can't do anything with my real estate. Peter can't change over my car to somebody else. But when I've passed away, Peter may be in charge of selling my house, of getting those bank accounts, paying off my debts, and then dividing the property according to how I wrote down how I want it to be distributed. There are more adults now than there ever were before that have adult children who are under legal guardianships, either due to some sort of mental incompetency, some sort of mental health issues, or even they've taken care of them at birth because of some genetic issue. Someone's under a legal guardianship, which means they're under a legal disability. They can't make those decisions for themselves. And when you pass away, a last will and testament can say, I am the legal guardian for my daughter, Susie. And so as a result, I nominate Bill, my husband, to be her legal guardian if something happens to me. And if he is unwilling or unable to, then I nominate Sally. And if she's not available, I nominate Peter. So, and the court has to honor those things. And as a result of that, you can decide who is going to be the best guardian for your adult child if something happens to you. And again, that's important so they don't become, as people used to say, a ward of the state. It's family that takes care of family, or a good trusted friend, and that's why wills are important. People often come in and ask this question. I'm the power of attorney. I'm the POA. And so therefore I can run things. Very, very important thing to say very quickly is a power of attorney allows you to help somebody when she's alive. But as soon as somebody passes away, the power of attorney goes away also. It dies immediately. But once you have a last will and testament that says, I, William, want all my stuff distributed to X, Y, and Z, and it's properly signed. And by properly signed, I mean it has to be signed by you in the presence of two witnesses who saw you sign and saw each other sign in your presence. It's very, very important because they might be called to testify someday as to whether that will's any good. But that's another story. Rather, when I have my last will and testament, say, okay, I did that, now what do I do with it? A lot of times in the old days, the lawyer would hold on to the original and give you copies of them. It's sort of flipped in the last 30 years, so now you get the original and the lawyer retains a copy so that the lawyer can say, whoa, hold the phone, I gave that to you and you signed for it. That way, they don't have the responsibility of holding on to the original. It's sort of smart. However, we lose stuff. We lose stuff at home all the time. I lose things at home. And God forbid you should pass away and everyone knows that mom or dad had the will at home and they can't find it anywhere. They even have copies of it and they can't find it. The best thing to do with your last will and testament in Ohio when you've made it is to deposit the original in probate court. It's a simple form. It costs you $5 and it gets a case number and it will be recorded and it stays in the court's vaults. It's forever safe that if something happens to you and you pass away, everybody in your family knows that the original is at the probate court and it's ready to roll. Only you may go and look at your own will. When all of us will pass away, so really most of us end up in probate court. Whenever you hear a commercial that says avoid probate, most people never avoid probate because a will is no good unless you get letters of authority from the probate court. But let's say you pass away. Someone who is the named executor and has a copy of the will can come and start the legal process of opening a probate case, and then he or she may look at the will. Your lawyer may look at the will to see if there is an older version of the will or a newer version of the will before he or she files, because it's it's a lot of money to file at probate court. Anything these days costs a lot of money, and so you want to save the money. But the answer is No, unless it's you and you made up a new will and you want to take out the old will, or you're moving to California and you wish to withdraw that will so you can take it with you to the state of California, you are going to be the only one that looks at that will. No one's going to be able to do the sneak and peek. If you have a will, the personal representative of the estate is called an executor. If you don't have a will, that person is called an administrator. Either way, in Ohio, that's the personal representative of the estate. So trust assured, the state of Ohio has worked this out over 100 years ago, how property is going to get divided. That's why a last will is important, so that you can decide who you want to get what and where and how.